Okay, party people in the house, you're about to witness something you've never witnessed before.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim? You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant.
Or the request is granted, the jury will disregard the statement and the question asked.
No, I definitely object to that, Your Honor.
Your objection is noted. Under 906.11, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please move on to a new topic or the cross-examination. I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will bring it to an end.
You don't gotta keep doing that, Your Honor. You don't gotta keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that, but it's relevant for the jury to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard
Correct.
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
not truthful.
All right, under 906.11, I am now stopping the cross-examination. Any redirect by the state?
Objection to that, and I would like a
Noted.
legal finding of fact.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
Objection, because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me see it, and I'll
when
take
did
your
it become an
objection
exhibit?
under, I'll take
It
the
was never an
objection under
exhibit before.
advisement. Go ahead,
I
Attorney
have all the
Opper.
exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I see it's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it.
Sir, do you recognize what's contained in State's Exhibit 178?
Objection,
Overruled,
relevancy,
overruled. Go
leading.
ahead and answer.
Yes, I do.
What is it?
There was a still photo shown before of Mr. Brooks
This is
standing in front of the
mind-boggling.
Ford Escape. This is the video in which that still photo was taken from
Where'd you get this video from, sir?
Mr. Brooks' social media account.
Your Honor, move to admit 178 and permission to publish.
Objection, Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that's not, that I didn't? even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
Actually, Your Honor, I changed my mind. I would like to play the audio, please.
Sustained.
This is mind-boggling.
So we will play the entire video, Your Honor.
Is this setting the foundation?
It's relevant. You
I
question this
question him
detective
about,
about
I
his
question him
knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The video's playing.
Mark got that heat.
I just got a load worth about a half a ticket. 30 in the blicker when I'm out here chasing chicken. Was observant to the game when I used to play the benches. Now I'm Spike Da Vinci, got them looking at me different. I can't miss him, yeah. AR with extension, yeah. Venom when I kiss him, yeah. Kidnap you and misses, yeah. Work all in the kitchen, damn. Money by the ceiling fan. Shorty wanna take a chance, I'ma need a cash advance. Only fuck with real gritters, and I've been around gorillas ever since a little nigga fucking on my babysitter. Put some prices on the nigga, you know they gon' come and get you. You see how the models did him, now he look like Tyson hit him. I was in the slums, any weather, I was still trapping, sliding on the pussy early morning. Bitch, you still lacking, caught him in the mall, had to tuck it in my heel figure. You know I got steel with him, fully not that little pistol. Heard they putting cameras on the lights, bitch, we still dealing. Give a fuck about the past, nigga, I'ma still kill you. No love for the suckers, listen, put them in the field, we bliss them, shoot out all the ammunition. They move like some caterpillars. Post this on your social feed, addies that extend release. Two boy, your talk is cheap, I won't stop till you deceased. Coming out your facial bleed, carbons, we gon' sweep the scene. Senses, we gon' find the heat, take you out the movie screen. Got another low, how we playing with them digits. Weighing up them bowls, selling coke around the digi. Playing with them bloods, they gon' pop you like a skillet. Nigga, I'm a menace, and that's working Mr. Wilson.
I hate that song. Why am I singing?
Oh, goodness. Hey, everyone. Welcome. Welcome. Hey, everybody. Welcome, welcome. Happy Wednesday. How's everybody doing today? Let me see who here. Hey, Wisha Karen Wood, Tammy Lynn, Vicky, Ravion or Raven, Meemaw, I said it was Karen Wood, Jeff, Kelsey. How is everybody doing today? Bazzini, I saw you earlier. Daniel Berry, Sports Highlights. Welcome, welcome, everybody. It's so good to see all of you back here. All of my Brooksaholics. Welcome, welcome, welcome. Now, I would be lying if I told you. What? Oh, here you go, Munchkin. I'd be lying if I told you that I knew exactly what I wanted to talk about. Hey, Aaron. About exactly what I wanted to talk about. So we're just gonna go and play. Hey, Super Kelly G and Kelsey. I'm just gonna start off with the COVID thing, and we're just gonna rewatch the trial, and we'll just take it day by day. Also, hey, Laurie. I just want to wish happy birthday to all of the cancers out there. I'm gonna have my I don't know how many 29th birthdays, but I'm going to have my 29th birthday this Sunday. Yeah, I'm about to be 29 again. Hey, Brenda. So let's all wish the cancers a happy birthday. Happy birthday. Happy birthday. Yes, we never get enough of Darrell. I am going to start doing some of the YSL since that trial is being placed on hold indefinitely. So we shall see what's happening. And what else I wanted to say? I don't remember, but we'll go ahead and get started. Hey, Beverly. We'll go ahead and get started with the COVID. Oh, I know what I was going to do. For anybody who wants to come up and enjoy and join in on the roasting, please feel free. Thank you. Thank you. Thank you. Please feel free to join in. If anybody wants to come and join the roasting sesh. Oh, happy birthday, California Dreamer. Wasn't it, Nene? Hey, Beans. Yes, the YSL trial is just ridiculous. Ridiculous. But you know, Lil Woody, I enjoyed Lil Woody. He made it entertaining, that's for sure. I know. I want to hear some of Brooks' jail calls too. Oh, and for those of y'all who were interested in the Al McLean, Dakota Collins case, come on, Munchkin. Dakota Collins case. I do have some more calls I'm going to bring to y'all. Please make sure that y'all look at that Dakota Collins case. I mean, I know it's triggering, but we need to have awareness that these type of people exist and they need to be taken down. All right, so let's go ahead and get the party started. Let me see. I'm gonna stop screen. Okay, I'm sorry. It's been a while since I been live, so I'll be having difficulties. All right. Yeah, and Muffin, it's worse. I pulled the court, like the sentencing memo, and they went in detail of what happened to him. It's worse than what we thought. With Mayor Tiffany, I am Jeff. I am starting to look at Tiffany Henyard. I just need to get caught up on it before I can start doing commentary on it. But she is on the list. I still got to do the that crooked bald-headed, half bald-headed pastor. I can't remember his name off the top of my head, but I got to do him too. Hey, Monica. So yeah, I got to do all of that too. It's all on the list. Hey, Annette. So don't worry, I'm gonna bring y'all some extra content for y'all. It's just trickling. There we go. Trickling slower than I thought it would be. But anyway, I know y'all don't want to hear me ramble. Let's go ahead and get the party started. I'm gonna get Tiffany Henyard. I promise I'm gonna get to her. Look at this hoe. Let me speak this on the line. Looking toe up from the floor up. Now I'm gotta look for my secret documents because these motherfuckers ain't gonna get me today. They ain't gonna get me today. I'm already ready. I got all my secret papers that I returned for value, except for value, return for. I got all my secret documents. Yeah, so I'm gonna just chill right here. Yes, my head hurts. I'm tired. I just want everybody to know I'm tired. I'm so tired. I was just hoping, come on and get on the panel. Come on, bitch, get out here. I got things to do. Get out here. Oh, thank you, California Dreamer. Oh, I'm waiting on Sarah Boone. She's gonna represent herself. I am ready, ready, ready. I just cannot wait for Sarah Boone. I can't wait for whenever they get Puffy. Because Puffy is gonna get it. Hey, Gen X gamer girl. Gen X gamer girl. What video games do you play? Look at Cutie Pie. Hold on. Yeah. Oh Lord, I gotta take this mask off. I know my breath stank, but I'm parched. My throat is parched. Yes, yes. Just refreshing. Take it to that. I wish this was some vodka though. I wish this was some vodka. Take it to the head. Yeah, yeah. Yeah, yeah. Take it to the head. I'm already sick of this shit. I'm already sick of it. Oh God, I'm just here. Don't put a close up on my ugly ass. Don't do that. My wide nose face ass. Don't do that. Yeah, all these white folks in here looking at me. All they doing is looking at me. But they think I did something. That wasn't me. And they know it wasn't me. Oh, there go Jason Statham. He got on his black on black crime suit. Yeah, I've got to go through these papers because they got my name misspelled. It's in all caps. It's in all caps. Oh, it's in all caps. I gotta fix this. This is wrong. Have they started talking yet? I guess not.
Sir, state your name for the record, please.
I'm here as a third-party intervener in
Intervener.
that matter, appearing as authorized representative for my client. I accept for value
Yeah,
and
you
return for
earned
value all the
value.
charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. Also, Your Honor, I would like to make an offer for my appeal. If
There
I
you go,
may.
Munchkin.
Um,
Here, Munchkin.
I'll get to that momentarily. The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today since they are not here.
Oh, hold on. Y'all got to see my co-host Paisley real quick. Hey, everybody. I got my little bandana on. Hey, everybody. How's everybody doing today? I went to school today. I went to puppy daycare today, and I'm tired. I'm tired. Hey, everybody. All right, Munchkin. Put you down. Get back on the blanket. I bet you leave soon. All right, back to the Dirty Darrell.
Here we are dealing with some housekeeping type of issues and other legal matters. So he is appearing today in jail attire. He is in custody.
Jeff, yes. The Brooksaholics, we are a movement. Hey, Stacy, Brenda. I think I said hey to Super Kelly G. Lori, I think I may have said hey to you too. But yes, being a Brooksaholic is a lifestyle. And, you know, I'm a proud member of the Brooksaholics Club, even though I do branch out into other things. But y'all, the Brooksaholics, you know, they keep wanting to see, you know, more of this idiot. So, you know, I just give y'all what y'all want. More of this goofball. Thank you.
It's my understanding, Mr. Brooks, that you were offered to appear in the suit, but
Vehicle, yes.
chose to come to court
Hey,
in jail
Amanda.
attire, which is fine. We're not in the presence of the jury. I just wanted to make a record of that.
Super Kelly G, yes. Paisley is named after Paisley Park. Yes, you got it. Before I even got Paisley, you know, I was going to sneak a dog in here at some point in time. But my husband's cousin, you know, she has several Shih Tzus, and they showed a picture of Munchkin when he was a baby, and he was so adorable. If I pull up a picture of him, he was so stinking cute, and I fell in love with him immediately. Let's see. I got my pictures of Munchkin. I got so many pictures of him. So this is Munchkin when I first got him. He looked like a little gerbil. Okay, so here is Munchkin. That ain't a good picture. That's a video. Okay, here's Munchkin as a little baby. If y'all can see him. So you see, he's that beautiful gray, and you can't even see his eyes about how dark he is. I saw that little face and fell in love. Y'all can see. See the little face. And then I promise I'm gonna quit y'all. And then here's Paisley being sneaky. Uh-oh, hold on. There we go. You see a little look on his face of him being sneaky. And then this was my baby after his first groom, after he got street legal. Y'all can see the thing. Yeah, there you go. That's when he was street legal. Got his first broom. And then you can see his color change. So, oh, and then this was, he went to the vet. And that was his little face at the vet. Anyway, back to Darrell. I know y'all want to see Munchkin.
I'll be consent or identified by the name that you stated earlier. I want the record to reflect that, if I may.
The record will reflect. Thank you.
She like, I'm
All
not
right, I
in the
know
mood.
there was some filings, and I want to make sure the parties have copies of everything. Mr. Brooks, I know there was an inmate communication form filed, I believe earlier this morning, requesting 6 subpoenas as soon as possible. I instructed my staff to make sure ample copies were.
He like, I'm so sick of this bitch. I'm not listening to her dumb ass. Why is she even talking to me, this white hoe? Why are you talking to me? Disrespectful bitch.
Did you receive those, sir?
I don't know.
No, I did not.
Mm-hmm.
We'll provide additional copies. Again, it's my understanding those were hand delivered to the jail, and that the jail took care of that in the event that that latter part did not take place. Mr. Brooks, I
Paisley's a shih tzu.
believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies. And when that is done and those are handed to you, I'll make a record of that.
I mean, y'all look at Judge Darrell.
We addressed the inmate communication form I sent about the.
I have a number of issues I need to address, so yes, we'll get to that.
Judge Darrell looks rested. Her hair is perfect. She looks absolutely perfect at the pretrial hearing. She didn't start getting tired, like really tired, until we got into week 3. But I mean, she looks phenomenal here. Just rested and just shining like new money.
You don't believe that has that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
So that means shut up and let her do her job. Yeah.
Will they?
I'm not seeing it in the record yet, so.
Because he's assumed a position.
So it'll refresh.
He assumed a position for Bubba.
The prosecution will receive a copy.
I believe one was printed now for them. It is in the record.
Hey, Michelle, thank you.
And then I'm going to print off something as well. I don't know if it was already.
Yeah, she does look like a Wonder Woman. Hey, B. Blanco. She does like Wonder Woman.
Respectfully, would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point before we go any further.
Preparing to do that. I didn't say I wouldn't do that. So give me a minute. I have some documentation that I'd like to provide to the parties as well. See, bitch,
Darrell, the judge is working. You see these screens? She got about 3 screens. She working. Let her work. I know you don't know nothing about having a job. Because you was working at the sheet metal place and then you stole Erica's EBT card. So I know you don't know nothing about no job. Let her do her job. Hell.
I want to confirm with Attorney Opper that you have now received a copy of that inmate communication form.
Yes, I have one in front of me, Judge. It's dated today's date, October 5, 2022.
What's the
It's
niche?
dated
Oh,
today because I just learned of the protocol that I would be on as of today.
as of today. Now, y'all remind me, was this on a Wednesday or Thursday when this protocol happened. Did y'all remember? Because I know that the day was what? He was like the earliest would be Friday, and I think that the court date was Wednesday, if I'm not mistaken. But y'all correct me. Okay. Oh man, bitch. Gotcha. Okay. So yeah, correct me if I'm wrong.
2 copies, 1 for each.
It was Wednesday. Okay. Thank you, Jeff.
All right, I'm going to provide a document to the parties. It's a 5-page document. It is a document that was forwarded to me at my request by Monica Paz, our clerk of court.
I ain't gonna read none of that shit. You can keep it up there. I ain't gonna read none of it. I don't even know why you're wasting the
After
paper.
receiving the inmate communication form from Mr. Brooks requesting
I don't
an
know where
adjournment.
Erica is. I haven't talked to her in a long
For the
time.
reasons stated in that document, I thought it important that we all have before us the current county protocol
Look how he's
related to
staring.
COVID-19. And so this will be provided to the parties.
Now, I decline to accept that if I don't believe
Sir,
that it's
it will be placed on your table, but I will be referring to that today, so
Is
it's
it
been
law?
given to you.
Is it verified law? Your
Is
Honor?
your booty law?
Attorney Opper, do acknowledge that the COVID-19 illness reporting
I
protocol was
respectfully
provided.
I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may. Because I have not consented to or agreed to accept any paperwork that,
Sir, it's been
He's not
provided
making
to you. It's
So are you
something I'm going to
making-
consider. You don't want to
are you
read it.
making?
You
are
want to
making a
disregard it. That's
judicial-
your choice.
Are you making a judicial determination that you don't have to answer that question I just asked you, Your Honor?
Now, if you want the lawful law, you see this book here. I keep pointing this out to y'all. This book here, that's your lawful law that you didn't open. That book is like straight from the bookstore, straight from the publisher, brand new, hadn't been touched. But that's lawfully law.
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not. So my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir. But based upon, and again, I did grab, I was provided with the COVID-19 illness reporting protocol. I wanted to make sure that I had the most recent information that at least the county of Waukesha is operating under. I also verified with court staff that the location at which you are seated is not within 6 feet of any other individual in this courtroom.
They don't want to sit next to you because you stink.
Is there any other information you think I should know as I consider your request for an adjournment today?
Yes, I find it hard to
Here we go.
believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically-
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate
and
communication form.
it could be verified because I was told when I was brought down here that everybody knew that I was on COVID protocol. That's why everybody
Because you
had,
advised us.
that's why, no, because the jail advised them. That's why they had to.
Okay, the jail advised them. What that got to do with her? What does that have to do with her? How is she supposed to know that this bitch boy had a COVID protocol, which we all know was a way for him to stall the proceeding? I tell you what, if Darrell had Judge Glanville That was the YSL judge who just got recused. If he had had Judge Glanville, that trial would still be going on to this day. They got to day 100 in that YSL trial. And I guarantee you, they only got maybe 40 days worth of actual work accomplished because of all of the breaks and all of the arguments and all of the BS from the state. So you decided to kill people in the wrong state. You should have did it in Fulton County, Georgia, and you would still be free. But you had to mess around and do it in Wisconsin. So that's your fault.
Wear masks to bring me down. That's why I'm essentially on a protocol that doesn't allow me out of my cell until my results come back.
Now you you're isolated in a cell by yourself. Ooh, so who are you going to make sick? The rats, the roaches? Who are you gonna make sick? Because you are high profile right now. So you are segregated from the inmates. So tell me, who are you going to see for you to be scared of the protocol? I can't leave my cell. You wouldn't leave it in no way.
So
Fool.
I'm not allowed out of my cell at the moment because of the protocol that the nurse himself placed me on, that the jail confirmed.
Who cares?
That is very easy information to obtain.
Sir, I
Just-
have
just like-
an attorney for the
Excuse me,
county
Your Honor.
here
I
who
don't-
will
I don't wanna-
verify
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due to
I don't-
HIPAA.
I don't want you to think
requirements.
I'm arguing.
So I'm not
Disrespectful.
arguing it with you,
I
sir,
know. I
one
just
bit.
want you to know that I'm not arguing with you either. But I was right in the middle of finishing what I was saying.
Who cares?
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go. Let me,
consent or-
No, bitch, you don't tell me what to do. You don't tell me what to do. You do what I tell you to do. You do what I tell you. And I'm talking. A man is talking. And you better bow down, ho, and listen to what I'm saying.
Let
agree to
me-
being cut off right when I'm trying
all right,
to
I'm just
provide
going to talk
appropriate
over him for a
information.
minute. I do not have any other information regarding the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication,
In the
which reads,
ICF.
due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if
That
you
is
so
not
choose.
true.
That is incorrect.
You a
because
lying hoe.
Just yesterday,
Uh-huh.
you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste,
A loss of taste,
fatigue,
fatigue.
and I have to wait for the results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain. And I find
So you expect Judge Darrell to start doing investigations. That's what the investigator over there for. The Jason Statham, my black on black crime fella. So he that's not her job. And if you were talking about your witnesses and you didn't want to provide your witness list, even though you had one. So she said, you get to go in the cell and get the list because they need the list for discovery purposes. So they could expect to have the stuff that you need because you don't have no documentation. You reading crap out of the box. Believe you me, what y'all say that opera looked like? The oatmeal guy. They are the Quaker Oats person. They already know what you got going on. They was prepared anyway. So I don't even know why we having this argument.
Find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff when there's a witness list involved.
Right.
We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor.
Dumbass, you just listed all of the symptoms that you had: a loss of taste and fatigue and whatever else you found on the internet or whatever else your mama told you or whomever told you about COVID at that particular time, because this is some crap you pull out of your stinking flat ass. That's where this came from.
So I'm afraid right now.
Hey, Tyrone.
I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered. And that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. I don't, like I said.
For the love of God, she didn't ask you what the name of the test was. She simply wanted to know if you had a test. And you could say it was a nasal swab or oral swab, or in your case, an anal swab, because I guess that's why you bent over. You had a thermometer or some other object implanted here. That's all I can think of why he's standing over, leaning like that in a position, in a submissive position.
I've never had this happen.
Let me clarify that. That was a pretty ambiguous question. So
that is a dolphin or a shark. That is a shit tattoo. All his tattoos are trash. You know, I watch on Pluto, the Ink Master channel. And so I have become a little bit of a expert on the artistry, because I find it so fascinating. And about having clean lines and color saturation, da 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 da. And I'm looking at this, just the naked eye, I can tell this is garbage. Blown out lines. I don't even know what the hell this is. This must be some jail tattoos. There's got to be jailhouse tattoos.
You reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, that it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
What's she supposed to do? Leave the bench, go over to the jailhouse and go to the nurses, whatever y'all call the nurse place, to go to the infirmary. There you go. The infirmary. She's supposed to go herself. The judge is supposed to go leave the bench or her office and her Starbucks and her Chick-fil-A biscuit and go to your cell to check up on you when you're the one that's claiming to be sick. Bitch, please.
But the jail can, because they control the movement.
Oh,
they control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the moment.
It's not, but I'm saying, How can
Look
I
at
tell
her.
you?
She's like, this dumbass. Hold on, let me get that look on her face.
Is not the issue at the
It's
moment.
not, but I'm saying,
Look at her. You said 6 bitches in count. Okay, Jeff. Yes, she got her Chick-fil-A biscuit with her strawberry jelly. That's delicious. I gotta have 2 strawberry jellies. I remember my husband came in and he brought me some Chick-fil-A. Well, he brought both of us some Chick-fil-A. And so there was some grape jelly in the bag. He was like, I hate fucking grape jelly. I have bad memories about my childhood with this fucking grape jelly. Oh, he went off about the grape jelly. And I said, well, I mean, it could be worse. You could have had apple jelly growing up. Now, that was disgusting. My mom loved apple jelly.
how can I tell you?
Hey,
How can
Miriam.
I answer what you're asking me?
Mm-hmm.
It doesn't make sense. We all understand that the
Huh?
jail itself controls the movement of the inmates. That's common sense, Your Honor.
That don't have nothing to do with the COVID test. What the jail doing the movements got to do with the COVID test? She simply asked, AXED, asked you, did you take a test and what type of test was it? We didn't go all around the booty hole. And here we are, still talking about the jail. I mean, I guess this is your permanent home. So I guess you would, be the expert on the movements and all that other stuff.
I'm not here to talk
I
about
can't- I
inmate
can't
movement
just-
at the
I can't
moment. What
just
I'm
walk to
asking
the
you is,
HSU.
do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Oh, because she was there and she saw them personally to know that you had a COVID test. Or she used the magical Marcus technique and just invented. She beamed there. She materialized there and she saw you. She got a crystal ball and saw you there.
Do you know
The
what
nurses-
type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday.
And y'all said it's Wednesday, right? And it's coming back on Friday. Yeah, look at them nails, man. You know them nails are trash. But anyway, so the COVID, you want to postpone the trial yet again because you're going to get the results of your test on Friday and it's Wednesday. Oh, I know what it was. Your goofy, stupid ass decided I'm going to represent myself. And so that way I have more time. And we can delay the trial. You didn't take into account that Wonder Woman was going to say, we starting on Monday. So here we go. We got jury here. We getting ready to roll. And then your bitch ass, that's 7. Your bitch ass, well, 8 now. You decided, I got another Hail Mary. I'm gonna say, I got COVID. Yeah, that's what's going on right now. COVID. Yeah, COVID. COVID. But you didn't do the math because the math ain't mathing. If you're supposed to be quarantined for 5 to 7 days, is that what it was at that point? You didn't do the math right. You should have taken a test that morning. And then that way you could have tried to postpone it till the next week. But your goofy ass decided, I went on Tuesday, and you just reported your symptoms on Tuesday, but you're about to tell us that you felt symptoms the last Saturday. Let's continue.
That's what I was told by the doctors. I would have to be at least on this protocol until the results come back, which
Were you
he said
Friday?
the earliest would be Friday.
Were you
Friday.
offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
So let's answer the question that was asked of you. Were you offered a rapid test? That requires yes or no. I remember when I was in law school, one of my professors said, when we were doing like oral briefs in class, and then sometimes the professor would, ask us questions to make sure that we understood what we were reading. And so some of us have the tendency to filibuster and, we throw everything at the wall and hope it'll stick. And so my professor, I will never forget, he said, I can tell, he didn't say this to me though. I can tell you really don't know what you're talking about. And I'm just going to say, like, my one cardinal rule is to answer the damn question. Answer the damn question. And if you don't know what to say, you don't know. But don't be up here making up stuff and gaslighting and going around the mountain. Just answer the damn question. Like this would frustrate me to no end. I hate when people do this. I ask you a question and you don't respond. I ask you a yes or no question. Well, they said they don't do it. But did you get one or were you offered one? They said they didn't do it. Okay.
If one can be obtained, are you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean,
look at Darrell. She amused.
I've already been placed on the protocol. I'm very afraid right now because I don't know what's going on. This is new to me. Oh. Like I said, I'm fully vaccinated, Your Honor. Mm-hmm. I've been fully vaccinated since 2021. And so for this to just be sprung on me now,
bitch, let me tell you something. You know that fully vaccinated people can still get COVID. It's just the infection is just not as severe. So yeah, you're fully vaccinated, but you can still catch COVID. Knock on wood, I haven't caught it. You know what? I think I might have had it before it was a thing, because I remember I was sick for like a couple of months and I had a really bad cough, and the doctors said that I had the flu. No, they first said I had a sinus infection. Of course, they didn't know what the hell they was talking about. If you're ever sick and you need to go to urgent care and y'all have an American Family Care in your city, please go elsewhere because they are going to screw you over. Like when I broke my toe on my right foot, they had written down the left foot. When I went to the sports doctor, they put it the left. But first they said my toe wasn't broken. It was just a bruise or whatever. So then the next day, the nurse calls me and says, "Oh, your toe is broken and you need to go immediately to the sports hospital." And then when I get there to get my foot x-rayed, she x-rayed my left foot. And I said, my right foot is the one that's messed up. And she said, "Well, who did that?" I went, American Family Care. So y'all do not go to American Family Care if you can help it. And so, yeah, Biden tested positive for COVID. So again, and he was fully vaccinated. So there you go. Trump was fully vaccinated at the time and he got COVID. So, anybody can freaking get COVID. Like, stop it.
Say this could possibly be a COVID thing. I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor.
Oh, but you weren't afraid as hell when you was barreling through the parade, killing folks and running people over. Why do you have this much emotion and this much bass in your voice for COVID, but not for little Jackson Sparks? Huh? The same age as Missy, your daddy's girl. How come you didn't have all of that for him? And you could have been heartless and didn't give a care about anybody else. But that one, then 8-year-old little boy who was the same age as your child.
That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results at bare minimum. At bare minimum. I don't think I'm asking something that's impossible for you.
If I can make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
I love
Not
it.
at this time.
Why not?
Why can't I get the results for the test I already?
Darrell, I love it. Why not? Why not? I love it. I told y'all Darrell does subtle shade. I love it.
And that's
Sir,
impossible for
if
your
I
honor to
can
grant.
make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results for the test I already took?
But you're telling me you're scared, you're
Yes,
fearful.
I am. I
But you
am
don't
very.
want to take a test that might
I
tell
took-
you today.
I took the test that he gave me.
Mm.
And
If
you're
he
telling me
felt-
that test result won't be available to you until at least Friday.
at least Friday. That's what I was
So
told.
tomorrow.
See, he don't want to take the rapid test. Oh, she said tomorrow, so this was Thursday. This was Thursday then, because she said tomorrow. But yes, the operative word is rapid. We don't want a rapid test. We decline the rapid test because we want to extend this. So this was Thursday. The very next day was the date of his COVID test, at least until Friday. So he was working on at least Friday, but maybe it'll, the results will come next week. This was his Hail Mary to keep this trial from starting.
I was told that I would be
So a
placed
day
on this
after.
protocol
Uh-huh.
until the results came back. The earliest that the results would be back would be Friday.
Tomorrow.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor. I
Okay.
have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar.
Hey, Sweet Pea. Yoo-hoo. Hey, Sweet Pea. Don't ignore me.
With some of the testing for COVID, there are tests that can be what we call rapid tests, or what are called rapid tests, that are
Giving too much
available.
information.
And then there's these other tests which take a few days. It's, again, I'm not a scientist, but I think the general belief would be sometimes the rapid tests are
So you're doing too much, Wonder Woman. You're doing way too much. He don't understand a word that you're saying. Rapid test and this test. He don't know what you're talking about. And I said Talm, Talm bout. I said that. Yes.
the lab that's being utilized.
See, it's too much information. It's too much. It's too much. Look at
I'm
it.
asking you once
He's like, I don't give a damn what you're talking about.
again, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I would
was
work
told
with,
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this?
Oh, you said that you had a loss of taste and fatigue and whatever other symptoms that you conjured out of the sky. You said that. So if that was the symptoms of COVID, they gave you a COVID test. And I guarantee you said, I think I may have COVID. I'm sure that's what happened. Oh, well, I don't know how they came up with COVID. I'm afraid for my life. I'm fighting for my life.
What is this about?
Uh-huh. Hey,
Well,
I had
did
a
you
Lisa.
report symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions.
Shut up. Hey, Carrie. Oh. Little. You know what? Hey, Carrie.
Why do I?
Hey, sweet
what's
life.
going on with this? Why is this? Why is this? Why is
Well-
that? Because I didn't understand.
Right.
Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms
Here we
prior
go.
to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue. With me
Okay.
feeling very fatigued, and I said, "Man, I don't know if it's just me being tired or."
It was your breath. You was breathing in those toxic fumes. You know, like when you huff the cans and the spray paint and stuff. So you got high off your BO and your breath, and that's what made you fatigued. I mean, those are noxious fumes, and if you inhale them, they could cause some serious respiratory damage. Because look at you. And then, can y'all tell me why he got an L on this shirt? Why does he need a large? He needs a medium. That's a small and a medium. He needs a medium shirt, not a large. And he looked dingy and dusty and dirty with these cheap, disgusting, horrible tattoos.
That's what I initially thought it was. Maybe I'm just a little exhausted, but I said no.
No.
Anybody knows their body. I said something. This got to be something more because I'm really. I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said. Okay, now I need to put the medical. Sick
When did you
card
report these symptoms to the medical people or to even just a correctional officer?
A few days ago.
So he reported it a few days ago, allegedly. But apparently, you didn't get a test until Wednesday. I detect bullshit.
A few days ago, over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired. Usually I don't just jump the gun and say something's wrong because it may just be, it could be anything. So
when did you report the loss of taste?
I reported the loss of taste last night.
But I thought you said it was a few days ago. Now it's last night. Oh, the day that you got your COVID test last night. Why was it last night? Because you knew court was going to start today and you wanted to postpone for as long as possible. Interesting.
And was it after that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
What?
Huh? They told you this morning, Thursday morning, they wanted to test you? Huh? The math ain't mathing. And yes, Charles? Yes, I know that he raps. If you look at any of my older videos, I do play his trash rap music. And I've written my own verse to go with this. We do a duet together. That song, With the Business. That's like the best song that he's made, is What the Business is. Anyway, let's continue.
What other symptoms are you reporting at this time?
That was it so far, just the fatigue and the loss of taste.
Could the loss of taste be the jail food? I mean, don't they get like a cold sandwich, bologna sandwich or something without any accoutrements, any condiments? Maybe that's where the loss of taste came from. And I guarantee you don't have any money on your books because don't nobody like you. Hey, Denise.
Which is the reason why I was told that I had to take the test.
This is a pre-trial hearing, Sweet Life. So they wanted to start the trial, but he claimed that he had COVID. So they're discussing his alleged COVID protocol that he's on, where he can't leave his cell and they won't get the test back until at least Friday. So I want to postpone all proceedings until. So that's what's happening. Hey, Denise.
Which I was told at that time also that the earliest my results would be back would be Friday.
And you took the test. Wait a minute. So you took the test today on Thursday, and the results are supposed to come back on Friday, tomorrow. I'm so confused.
You said at this point you're not willing to take a rapid test.
Well, they said this is the test that they do. The nurse was very clear in what he was telling me. when he told me how to test, because like I said, there was a lieutenant and 2 officers right there while the whole thing was going on.
I understand all of that. I have a very specific question to
I
you,
was
sir.
asking them questions, and he specifically told me that this jail, this is the test that they do. They do not do rapid tests.
Lies.
I didn't even ask about the test because I know nothing about the test. This is what I was told. And after,
So they volunteered and told you that we don't do a rapid test. But you had no idea about it. You didn't ask any questions. And so they just volunteered and said, we don't do, shut up.
after he told me that, I said, okay, fine, just do the test and I'll just sit on the protocol. Because at first when he told me, you know, you're going to have to be on a protocol where you're isolated.
You're already isolated.
I said, okay, fine, just do the test. I'd rather you do the test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait for it to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed. Friday would be the earliest that I would get the results back. And I would be placed on a protocol, which is called isolation, where I'm not allowed out of my cell.
You're already isolated, bitch.
Anything else, sir, you think I need to know about this issue as I consider your request?
Look at his little
No, at this time, I'm just telling you what I know.
Which is
multiple
nothing.
officers were there. They can tell you the same thing that I'm telling you now. Like I said, Lieutenant Chamberlain was there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
You should have said absolutely yes, because
Given
you're
any
gonna get caught
information
lying.
about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is.
So no information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information, because like I said, I'm limited in the pod that I'm in. I don't have no interaction with any other inmates.
Oh Lord, my light fell. I'm sorry, Munchkin. My point that I was trying to make before my light fell. So you don't have any interaction with the other inmates at all. You're confined in the mental health pod. So what is the point of this? What is the point? Hold on, I'll be right back after I get my setup back, but let me hit play.
And my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information. I know, sir, what I've provided to you is generally the, for employees, I fully recognize that the jail may have different protocols just because of it being in a correctional facility, and inmates are, of course, or can be very close to one another. And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their protocols are as I consider this request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom. As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols. And despite you reporting fatigue, I know, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table.
I got a knee on the chair.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court as an officer of the court and as an offer of proof that he has.
How could
Mr.
that?
Brooks, did
how
you
could that
hear
even-
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond.
That-
I'd
that's
encourage you to use
That is
paper and a
ridiculous,
pen
Your Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand that this is a place of dignity. It is a place of respect. It demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so. I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare for this case. As we've learned already, and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell. He has a tablet made available to him in the confines of his own jail cell. And he has the ability to use a conference room in his pod. I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
I never once said...
Mr. Brooks,
I never
have
said
an
I never
opportunity
no,
momentarily.
No,
You
I
need to be
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks, it's not
she
your
said-
time
no,
to speak.
No, I
No.
respectfully object. I never reported saying what day. I never said a day. And if she's saying
You
she
said
has
a day.
jail phone calls, well, why aren't they present? Why
What?
can't they be verified by sworn affidavit and brought into this court to
You
be
really
shown
want them to do
that
that?
this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little
Just
bit of
like-
leeway
just like you're
because we
saying
are outside the
That I
presence
waived
of the
something.
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect tested for COVID-19. How could that be a delay tactic? If that
How?
was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
A, you stink. And then two, that was a dumbass question. If Hold on.
Be a delay tactic. If that was a delay tactic, why would I even need to be tested and placed on the protocol? Why?
Because it was a delay tactic. That's why you need to be tested and placed on the protocol, because it's a delay tactic. If it wasn't a delay tactic, then you would set your ass down on that concrete bed of yours and just, power through. But you did this in order to delay. That's why they said it's a delay tactic, because that's what it is. I mean, we got to start calling out the truth. It's not, I was trying to bake, looking in the magazine, trying to get a recipe for cookies. I'm trying to delay this trial because my dumb ass hadn't read not shit, not one piece of paper. And I mean, I've been so busy, touching myself, rubbing on myself, thinking about, man, I wish I had me a woman and I ain't gonna never have no women again. Oh God, I'm just gonna be here for the rest of my life. But maybe if I lie and I continue to lie, and you keep the lie alive to the very end, maybe I can get off this thing.
Does everybody have to have on masks to bring me down here?
Because you stink. Hell.
All right, Mr.
Is
Brooks,
there no-
I've
is there
given
no
Mr.
verification?
Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to
twice.
be able to speak up.
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had you provide
that was not
information.
polite. That was abuse.
That's
Oh,
the
it was
third
abuse.
interruption of this court.
That was abuse by the prosecution. That was
I tell you what, I wish that you could take your ass to Fulton County. You don't know what abuse is until you sit with Attorney Love. That's abuse. That's abuse. But hey, whatever. You keep talking about the Quaker oatmeal lady abusing you, but you ain't seen abuse yet. But you wouldn't know abuse because you're abusive and you're a bastard and an ugly ass.
was abuse.
Mr. Brooks, let me finish.
No, because that's
So he now he's
Yes, you missed
outright
papers,
refusing
Robin.
to listen.
I would
He's
not sit
outright
here.
talking over me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks,
Kick him out.
we are at the point yet
I'm
again
not
where
gonna
I
sit
will put you in the other courtroom because
and
you
I
are
don't
not
consent. I don't
able.
consent to being removed. I have not waived the right to be present.
Bitch, you're literally shackled to the desk. What are you talking about? I don't consent. I don't consent. And you can't make me. Yes, they can. I wish the shackles was on you so they could shock you. I told y'all I would be on the button. So I'll just be pressing and pressing and pressing. There'd be smoke coming out of his ears. All of this would be just smoke. Poof. That's what I would do.
And I don't agree with that.
Mr. Brooks.
Does the
I
record
have
reflect?
provided you on multiple occasions and it's should be in front of you.
No,
And
I don't acknowledge that. I haven't agreed.
You
to
have been
it, and I
advised
haven't
on
given
multiple
consent to it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are.
Judge Darrell, I don't know why you're trying to tell him about being considerate and decorum. He don't know what none of that means. And even if he did know what it means, he doesn't care because a woman is talking to him and he don't respect women. And I know some people say that he was racist and he might be have some of those tendencies. I don't think that was the why he ran into the parade, but he didn't listen to you. You telling him all this stuff. He ain't interested, girl.
Are now acting as your own attorney by representing yourself.
I don't recognize the name
that all of the rules of courtesy and decorum apply to you.
I don't recognize that name, Your Honor. That
Supreme
is not who
Court
I am.
Rule 62.02 details many of the requirements for for courtesy and decorum. I've referenced a couple of them on multiple occasions, including that sub 1 sub F of 62.02, that proper conduct and attire is expected within the courthouse, and where possible, individuals, including yourself, right, are to refrain from creating disorder and disruption. Sub H, you're supposed to conduct yourself in a manner which demonstrates sensitivity to the necessity of preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the expectation that this court has that you conduct yourself in a civil manner. You've been advised multiple times that this court will not tolerate disruptions, interruptions, that when you do that, you run the risk of forfeiting your right to be present in the courtroom. As you know, I have available the courtroom next door that's connected to the holding area.
There we go. She about to make the biggest mistake. She about to make a mistake and say that I found a fourth option. So of course, you know, he holds on to things that he think will help him. Oh, you know that's illegal. There wasn't no fourth option in the law. That's illegal. It's not lawful law.
It is connected by audio and visual means. It provides you an opportunity to meaningfully participate by also giving the court the opportunity to control the decorum, to control the disruptive behavior, because primarily your disruptive behavior is repeated interruptions of this court, talking over this court, now talking over the prosecutor. I appreciate that you have not interrupted me for quite some time. So at this point, though, I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audio-visual means. At this time, I would like to hear from the court administrator, especially as it relates to the protocol.
Jail administrator.
Did I say the court administrator?
Yes, that's all right.
That's okay. We're in court, and I would like to hear from the jail administrator. Thank you very much. And just to get some general information and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who are present. So I believe we have Angela Wallenhopt here, if she would come up to the witness stand.
I don't want to mix issues, but the inmate communication form from September 28th also still needs to be addressed by the court, and I think the jail administrator may have some information relevant to that issue as well.
All right, thank you. I
Please.
have a list of a bunch of things I want to go over, and I'm gonna.
So, Your Honor, respectfully, just so I'm clear, are we addressing the issue at hand now,
We are.
or are we addressing something from September?
Well, I will get to the September.
You dumbass. She said that we need to address that after this, but she didn't say we're going to address it now. She said there's a thing that's in September. I think that the lady can she can testify to that as well. So we can knock out two birds with one stone. Active listening, critical thinking. Let's try it.
Inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication form that is dated October 5, and that addresses your request for an adjournment. So I'll have you sworn in. I'll just do it. Raise your right hand. Do you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
He like another white bitch. Another one. This courtroom full of white bitches. So here she come. white bitch.
Would you please state your first and last names for the record?
Angela Wallenhop,
Would you spell your last name?
WOLLENHAUPT.
Thank you. If you could please advise us on the record
Look at him. He looks scared. That's why his eyes keep shifting. He's scared because he know he was lying.
again of your job title and responsibilities.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Could you provide information to the court on the general COVID protocol within the jail?
Judge, I would prefer to not speak to the operational considerations with that. I can speak to the fact that there are different protocols that are put on people for different medical or management reasons, which may have modifications to them. I can speak to the protocol Mr. Brooks has placed on, that it won't affect the area he is living in, nor access to areas that are not other inmate occupied.
That seems fair. I don't want to certainly put all of your operations on display. That's not necessary. But if you could speak to the specifics as it relates to Mr. Brooks's current situation.
So he would remain in his current cell housing location. He would have access
What trial, LaShondra? Which trial do we need to watch?
to a conference room if he needed it, access to a telephone. And we would be able to, it's a safety security measure for him as well as our staff. And we can safely produce him for court.
Look at his face. Oh, I told y'all he got very expressive eyes and his little forehead creases. He could use some Botox. He really needs some Botox. But you see his hairline, you see it's pushed back. So he's running from his breath, number one. And then these are his demon horns. They're already sprouting. This right here, demon horns. And like I said, it's running from his breath. That's why his hairline pushed back.
When I hear the phrase being on a protocol, that to me could have more than.
So here's my thing with the YSL trial, LaShondra. The YSL trial is freaking dull. It didn't get interesting until Lil Woody. And I have to confess, I really wasn't paying it that much attention, but for like a month and a half ago. So I can go back to the beginning, but like the trial is freaking boring. It was one day where they were talking about how Jeffrey Williams, that's Young Thug, how he rented a car, and they literally talked to the person from Enterprise Rental Car for the entirety of the day about the process to rent cars. I was like, good God. Hey, Della. Anyway, let's continue.
Than one reason. Someone could have been exposed, someone could have tested, or someone could have reported symptoms that required testing. Would I be mistaken in any of those beliefs?
You are correct, Judge.
Would there be any other reasons for someone to be placed on a protocol, a COVID-19 protocol within the Waukesha County Jail?
No.
Uh-oh.
And would you tell me which one of those three options has prompted the COVID protocol for Mr. Brooks?
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based
however,
on information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail.
Oh my gosh. They asked, would you be able to talk about you? They're not talking about the jail. They're talking about you, dusty bitch. You. Oh, look, Witty is crazy. I love it. Oh, it's yes, Ty. I'm waiting for the Sarah Boone trap. They televise it. Please, God, I hope they stream it. If they do, I am definitely covering Sarah Boone as best I can. If it's something like they did with Nature Boy, that's going to be more difficult. But if it's streamed live, and I suspect it would be, with how everything's been going, yes, I will definitely cover Sarah Boone because she's representing herself. So I would love to see that side show.
I'm not speaking about everybody's situation is different.
Mhm.
Right. And I'm specifically referring to your situation.
That's right,
Well,
Ho.
the question was asked, and
You don't even know
how
what was
does it
asked.
pertain to me? It was pertaining to me, all the questions,
Ru-
which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Oh my hell.
Right. I'd like to verify the information that you're providing to me regarding what was reported by you, what tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask her about?
No,
Hell
I do not
no.
understand.
Mm-hmm.
Did you hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would provide that
No, I don't
information.
understand.
So
I didn't consent to understanding or agreeing to that. No, I do not understand.
all right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
Okay. It was brought to my attention shortly before the lunch hour that he had
Uh-oh.
made statements that prompted the medical department to follow up. As I said
Mhm.
before, I have not reviewed the medical record. It is my understanding he was administered a test.
Mm-hmm.
He was also offered another test, to
Uh-oh.
which he refused.
Mm.
Do you have any information regarding whether this other test would have been a rapid test?
I believe it to be.
Oh
Do
no.
you have those tests available in the facility to offer to an individual?
I have one available right now.
Oh no. The rapid test that you said they didn't do. They got rapid tests. Oh. They got rapid tests.
Can I ask a question, Your Honor?
Of me or of the witness?
Jail administration.
Go ahead, you can ask a question.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test,
Uh-huh.
then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. Why?
Sir, what's the question?
I asked the question, why would I not be given the correct test from the get-go instead of
The
having to take
get-go.
two tests? If I've already taken
Mr.
one
Brooks,
test,
you have to give her an opportunity to answer, and you
I've
gotta
already-
ask one question at a time.
I just asked the question.
Can she
Well, then
answer
shut up
it?
and let her answer.
Do you want her to answer it?
Hell.
I presume you do since you asked the question, so you need to stop talking so that she can answer it, okay?
Limit your abuse, Your Honor.
Limit
I'm
your
sorry?
abuse.
I don't appreciate being talked to that way, Your Honor.
White bitch, I'm telling you, you better respect my authority. You better respect my authority. I don't appreciate this hoe. Don't even do it, snowflake. Don't do it.
Your objection is noted. Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said 2 tests. If it was,
No, bitch, you said the wrong test. You said, how come they didn't give me the right test at the get-go? At the get-go. Well, I administered the wrong test. That's what you said.
why would I need to take 2 tests for the same symptom?
Your Honor, I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
And it's stupid.
All right, so I'll sustain the objection. I'll give both parties an opportunity to ask questions of this witness since it's Mr. Brooks's request. I know do you have any other questions for Jail Administrator Wallenhupt on this issue at this time?
Yeah.
I don't think I was clear, or I didn't have clarity on the answer to that question. Essentially, what I'm asking is, why would I need to take 2 tests for the same thing? There shouldn't. If I'm taking a COVID test, why would I need to take another one?
I'm going to object to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Mind-boggling.
A different question?
Would it be any way to verify why I would need to take 2 tests for the same symptoms?
I'm not sure I understand the question, sir.
It don't make sense.
I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallenhupt.
And that's why it's hard for me to wrap my head around why Mrs. Wallenhoff would be called to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I say
I understand what you're saying. Do you have any other questions for her, though?
Are you sure you wrapping your head around what I'm saying, Your Honor?
Do you have any other questions for this witness?
The disrespect. Like, how are you going to patronize the judge who is smarter than you, better looking than you, has been to school longer than you, and actually was elected, and she got her name over here, right here, and she's the judge deciding your fate? I don't know. I don't know. Oh, just like with people, you don't screw over people who fix your food, or if you're a sister, people that do your hair. You be nice to those two people: the food, your server, and your hair.
To your knowledge,
Come on.
you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now.
Uh-oh.
As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Because you refused.
Relevance.
If she knows, she may answer.
I do not know the answer to that. I have not reviewed the medical record, jail contracts with the medical provider.
Thank you. Next question, if you have one.
So there are more than one type of COVID test administered by this jail.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with the medical provider. I do not direct testing for medical conditions. That would be our medical contract.
Hey, Kelly,
I
welcome,
believe the record's
welcome.
clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that he did submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given her role in the
African man trait? I don't know what that means, an African man trait. And number one, I don't know what that means. And number two, he's not African. He's a dumbass. And I don't think any group of people claim him. So I'm not exactly sure what you mean by that. But I will say that he's a thug who has been educated by the streets, and that's SKREET, the streets. And he adheres to thuggish, ruggish culture, you know, the thuggeration. So, but to answer your question, I have no earthly idea.
Waukesha County Jail as the administrator and not in charge of medical. I will find she does not need to answer that question because it's outside her scope. And
You don't know what that means,
further answer it might be speculative. So do you have another question?
So would it be fair to say, you just said it would be speculative. So would it be fair to say that it'd be speculative that
Speculative. I hope that we're keeping up with our dusty Darrellisms. Speculative. Hey, Glenn. Speculative.
the second test would be a rapid test?
You fixated on that rapid
I will
test.
make a determination on your motion after all of the evidence and testimony on this issue is received.
Is that an
I
answer,
can't
Your Honor?
answer that question.
That's
at
the
this
Well, I'm
time.
answer.
asking it of Ms. Wallenhoff. Is it because you just
Bitch, she said that she can't answer that question. Good God.
you
Whew.
just said it would be speculative?
Well, you just were looking at me when you said that.
Well,
So are you, and I'm not going to answer that question. I'm not a witness in this.
The
I
reason
make
why I
the
was-
determination
reason why I was
ultimately.
looking at Your Honor is because
Do you have another question
I'm
for
still trying to
Jail
figure out
Administrator
how-
Wallenhaupt?
I thought testimony was supposed to be the prosecution and the defense's time to
Sir,
ask
do you
questions.
have another question? Otherwise, I'm going to
You're
ask the state
asking
if they have any more from
questions.
this witness.
I asked the question, would it be fair to say that it's speculative about
Speculative.
what the second test actually was?
Mr. Brooks, I don't understand your question.
It don't make sense.
What isn't to understand about it? If you were offered a test,
Uh-huh.
Relevance.
no, it's a question.
Hold on.
I'm
You're
getting
asking
I'm
a
going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer, but you can go ahead and ask it.
Well, it's not hypothetical.
It's hypothetical.
It's very logical.
Oh.
If you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
Right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay, so
question,
why-
and
so
it's
why would I
not
do it?
relevant. So
why would
sit
I do it
down.
then?
You're done asking questions because you've
So
now
is that a
asked.
judicial determination?
I
Yes,
haven't
she's
made
a
a judicial
judge.
determination yet.
She's a
You're
Go ahead,
judge.
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
certain
Brooks?
questions of yourself.
Mr. Brooks, okay, here's your warning. I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be removed to the next courtroom.
I don't consent to
Uh-huh.
being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional right to be able to do so.
Uh-huh.
I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not
Thank
consented
you.
to
Ms.
an
Wallenhoff,
estoppel.
although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery?
Vivini, I am proud that you know about the Socratic method. Yay! Yes, the Socratic method. That's when I was telling you about my law professor was telling people they need to answer the damn question. There you go.
Materials in his jail cell?
Yes,
Jay, for relevance.
To your knowledge, are those materials?
the objection is overruled. Go
I'm
ahead.
sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that,
he
Your- I
still
object to
able?
that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be able
objection
to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I
you
am
haven't.
turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And-
when I was asking
Right,
questions.
and when the court rules on an objection,
Mm-hmm.
usually the party who objects stays silent.
I'm-
I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question.
Who
Attorney
gives a
Opper.
rat's
The
ass?
judicial determination.
Ms. Molenhop.
that you are making.
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And
Uh-oh.
that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
Uh-oh.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
Uh-oh.
Nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So an objection goes to whether there's lots of rules of evidence that
Yes,
apply.
yes.
But if you're objecting to her answer, that's a different thing. You can argue the meaning of that language.
question.
Okay,
Not
the
the
objection, but then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She didn't
answered.
answer the last
The
question.
objection is
Oh my
noted, it's
gosh.
overruled. Her answer may stand. Next question.
Shock him.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail,
I
correct?
respectfully object to that.
Overruled. She may answer.
Correct.
He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Why?
Overruled. You may answer.
Correct, ma'am.
And
So you're gonna
Hey,
overrule
Janae.
everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for
Oh.
you. See that big book over there?
No, I don't.
It has
Uh-huh.
the criminal
I
statutes.
don't see.
Uh-huh.
It has the traffic code. It
I
has the
don't
rules of
Uh-huh.
evidence. Well, it's
Mhm.
on your table. It's behind the microphone and it's
Right
there.
here.
I've provided it to you as a courtesy so that you
Right
have that
You did
available
not
to
provide
you.
anything to me.
All right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
something
I've
that-
provided
Bye, bitch.
ample opportunity
never-
for Mr.
I've never
Brooks to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack
don't
of
give
consent is
consent.
noted for the
I
record.
don't
No
give
one cares.
consent to an estoppel. I don't.
I'll
give
make a more
consent-
full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent
Ah.
to be removed.
Madam Reporter,
being
the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off.
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Ah. So the injured parties have no claim according to you. Gotcha. Gotcha. He is so infuriating. Oh Lord. I'm just doing all type of stuff. Let me see they come back. Okay. So let me go to the next one. Give me a second here. I usually have my stuff pulled up. He should have got Earl Glanville as his judge. He would have been so much happier having Ural, or urinals, I like to call him. Is this? Oh, this is one where he was firing his attorneys. Is this the one? Oh, part 2. Okay, hold on. Oh, I guess I got to check this off the screen, don't I? All right. Okay. No, that's the wrong one. There we go. All right. I'm going to do just a little bit more. I don't want this stream to be too long.
Until I muted him, I can see him. Can we please get confirmation from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well. Prior to the court ordering Mr. Brooks removed from this courtroom to the neighboring courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. I have cited repeatedly from Illinois versus Allen, which is the Supreme Court case from 1970, which provides this court with the authority to remove Mr. Brooks from the courtroom. Because it is a new day, I think it bears repeating much of the language that is directly on point in this decision. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom, nothing unconstitutional. I've also cited repeatedly to SCR Chapter 62, which contains the standards of courtesy and decorum for the courts of Wisconsin. I've advised Mr. Brooks repeatedly. I've had, just as I am holding a copy of Chapter 62 on yellow paper laminated, I have it myself. I provided it to the state. I provided it to Mr. Brooks. And those standards govern what I do, what the attorneys do, what lawyers, clerks, court personnel, even witnesses refrain. Once again, I gave him ample opportunity. I understand he can object. Whatever it may be, right now demonstrating for you. Even if it's striking.
Digital discovery materials, you testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold
about.
on a second. Mr. Brooks, the basis for your objection at this time?
That it's irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room for a tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opper, with your next.
You told them in the beginning of this fiasco, you told them this needs to be postponed because you don't have access to anything and you're locked down in your cell 23 hours a day. Even though you have all the boxes, all the exhibits, you have all of those. So that's why they're talking about you being in the cell and the length of time there, because you, dumbass, brought it up. Idiot.
Question.
The nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day.
Objection.
Objection.
There you go.
Overruled.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a card available.
Sure. Mr. Brooks had told this court earlier that he started feeling not well, I believe were his words, over the weekend. And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Or just a comment under your breath? Your objection's noted. It's overruled.
Of course.
if he were to complain
course
of
it's
illness
overruled.
to a correctional officer or a lieutenant,
look at
would they
Jason
document
Statham.
that in any way?
I didn't
They
notice
would give
that.
him a medical request form
Oh,
to fill
wow.
out, which would go to the
A jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Or just a comment under your breath? Your objection's noted. It's overruled.
Of course.
if he were to complain of illness to a
Look at Jason Statham. So now we know that there had people there who laughed at this dumbass. And it was my Jason Statham. I know it was my first time seeing it too. Hey, Amber Kiva. But anyway, yes, this is the first time I've noticed that he laughed. So now we know these people was laughing at this dumbass.
correctional officer or a lieutenant, would they document that in any way?
They would give him a medical request form to fill out, which would go to the medical department where he could have contact to medical staff, or it could be documented in the jail management system.
To your knowledge, was that done by Mr. Brooks last weekend, the weekend of September 30th and October 1st?
Nope.
Not to my knowledge.
And are you aware of the fact that last weekend, on or about Saturday, he requested a shower and a shave?
Yes.
Was that provided to him?
Yes.
That was probably his first shower in about a month. He's like, well, I got to look good, for court, so I can have on my nice, clean jail uniform. And, I'm going to get into my big boy suit, but I got to be nice. I got to be fresh. I got to be fresh to death when I go to jail. So I need to shave and shower. I got to shave off this scruff so nobody will recognize me because it wasn't me there anyway. I got to shave off my hair because it wasn't me anyway. Ha.
If he weren't on a protocol, would he still get those things? Or does it depends?
It would depend what type of a protocol.
Okay, thank you.
Those were all my questions. Thank you, Ms. Wollenhop.
All right, Mr. Brooks, do you have any follow-up questions for Ms. Wollenhaupt?
Yes, I do.
I do.
Here we
You
go.
stated that it would depend on what type of protocol I was on,
Come on.
would dictate if I'm able to shower, correct?
That was not completely what I stated.
Well, that's what you just stated on the record.
Well, different management protocols, it would be in accordance with jail operations, and my preference, Judge, would not to be to speak to all of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a fair question.
Don't help him.
So that would be the question then. Let me ask this. What specific protocols would prohibit being able to shower?
Objection, irrelevant.
I'm not going to, it's sustained. Mr. Brooks, I'm going to honor the
But you gotta
request of the jail
shower.
administrator not to talk generally about protocols, given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation being a little bit unique, would any protocol that I am on currently prohibit me from being able to shower and or shave?
Do you speak moving forward?
As of right now,
You would be allowed to shower on the protocol you're currently on.
would I be
Uh-oh.
able to shave?
You would be able to shave.
Would that be with the clippers or a razor?
Objection, relevance.
Overruled, she may answer.
Clippers or
Mr.
razors?
Brooks, we would monitor behavior and other factors in that and make a determination. There's procedures operationally in the jail that you can request those items. And you
That would be independent of the COVID protocols.
correct, ma'am.
So to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being housed in the jail, and we are only permitted razors once a week and clippers only once a month?
Wait a minute. Wait. Didn't you say that you can't speak for the other inmates in the jail because you don't have access to them? So then why now are you talking about rules that the other inmates have to go through? Well, didn't you know that there's maybe I only got razors for a month or for 1 week, and it has to be taken and clippers. You know what, Darrell, since she's the jail administrator, I think she knows. Oh, hey, Munchkin. He left and came back. I just felt a little fur ball on my foot.
Judge, I would prefer not to answer questions in regards to jail operations.
Right, I'll
Oh.
honor the request of the jail administrator. It goes beyond the scope of this hearing. She need not answer general questions about the general procedures and protocols within the Waukesha County Jail.
He's like, well, damn it.
We're a little
No,
far field. I gave you a little bit of leeway, but we had started this off about COVID protocols and your current situation. So from my perspective, the questions regarding the discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room. That to me implicated your ability to prepare for your defense in this trial. So that's why I allowed those questions. Whether you shower or
Hey,
shave
Aaron.
would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Well, respectfully, Your Honor, that was brought up by the prosecutor. It
Huh?
was brought up about the whole issue of being able, me requesting to be able to shower and shave. So that's why I brought it up in my question.
I understand, and I'm under my authority under 906.11. I'm going to advise both parties that anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any further, at least today on this particular issue.
Thank you, Your Honor. I would want to make one correction for the record. I never claimed not to be able to have access to
certain things. I merely claim that I am on a protocol which limits me even more than I'm already limited. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that.
You're already restricted to your cell and you're isolated, sir. So it doesn't matter. You just don't want court to start. You want this trial postponed. And like I said earlier, you should have committed this crime in Fulton County, Georgia, and it would be postponed indefinitely.
That clarification, sir. Thank you. Do you have any other questions for Ms. Wollenhut?
Yeah, a couple more.
Okay, go ahead.
Okay. Out. Come on. Go in your secret documents.
Would you care to share with the court on record the types of protocols that I am currently on outside of the COVID protocol?
The dumbass protocol.
Goes to jail operations.
Sustained. Next question.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials,
90611.
I'm going to have her not answer that as it goes to.
Well, that directly goes to that because, as we know, I'm only on a protocol where I'm only allowed out of my cell a few hours a day as it is. Now being restricted to my cell because of the COVID protocol, the question I'm asking is, does that restrict even the time that I can be able to be out to utilize the things that I need? Because essentially, I'm only limited. I'm already limited.
Can I ask?
There's times.
I want to make sure I follow you, Mr. Brooks, so I'm sorry for the interruption. If I hear what you're saying correctly, you may have a belief that your access to certain things that would impact your ability to prepare for this case is impacted by the COVID protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
In a sense.
And so if we ask the jail administrator that specifically, is there anything about the COVID protocol that would interfere with your ability to have access to materials or a room? Is that a question you would want answered?
That would be fair enough.
All right, do you understand what he's trying
So
to
what
ask?
I'm understanding is, obviously, Mr. Brooks is allowed to keep legal material in his cell. He will remain in his current housing location. Access to the conference room, it will not change that, which is outside of his housing unit. And access to the phone could be granted upon request in the day room area.
All right.
So I do not believe the protocol limits his access to legal material.
Thank you.
He's
Do you
not
have
going to
any
read
other
it anyway.
Yes, I do. As far as she just referenced the telephone. To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that
Let's not talk about other inmates, but are again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking.
Okay, let me ask it another way.
Okay, go ahead.
Please do.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask
X.
I guess I'm unclear as to the manner you speak of. What are you referring to?
He don't know.
I think I was very clear.
I think I was clear.
With
That's when he started to get mad. But I think it was clear. No, it's not clear. Oh,
Are you trying to
You are
ask her?
aware- Are you aware, which I know you are, that the protocol that I'm on outside of the COVID protocol prohibits me from being able to utilize the phone at certain times of the day? Would the COVID protocol prohibit that any further?
for the love of
Mr.
God.
Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
That's what I just said. No, not in a sense, because
Good God.
I think it's more accurate with the way that I asked it.
But your question
Yeah.
assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the COVID protocol has on your ability to prepare for this case. So I'm going to limit your questioning in that way.
Well, can we at least make a clarification on the record that the reason why we're having this didn't have anything to do with limiting my preparation?
What?
So
That wasn't the real issue.
What?
I think it's related to
I just
the,
wanted that clear. I just wanted that clear.
I understand.
That's all.
I understand what you're saying. I respectfully disagree. That's why I've allowed some of the questioning. I believe it's relevant to the motion that's before me for this court to know how the COVID protocol specifically impacts you and your ability to prepare for this case. I understand you might not be claiming the latter to be an issue, but nonetheless, I think it's appropriate for the court to consider those things. I heard the jail administrator indicate that the phone privileges would still be available upon request. And I guess to the extent that that's different, if at all, from the standard protocols that you're under, I would accept that as an offer of proof from you.
Well, I didn't agree to that, but the reason why I brought it up was because I've been on outside of the COVID protocol. The protocol that I've been on for a very, very long time. So my phone use is limited to certain hours of the day, which works out.
All right, Mr. Brooks, we're getting a little far field. I need to make a determination on your request. So I'll ask you one last.
You haven't let me finish what I will.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator? Because right now you're talking more about things you would provide. So if you have a question that's relevant, please ask it.
I didn't say anything I would provide.
Good Lord.
Where did I say that?
When you provide information through just a statement about things, that's not evidence, right? The witness on the stand is providing us testimony. Testimony is evidence. Not that I wouldn't accept certain statements from you, but also understanding the state has the ability to challenge those by asking questions of the jail administrator or other individuals so that I can make a determination today on your motion. With that, Mr. Brooks, do you have any other questions for the jail administrator?
Well, everything you just said still speaks to not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not answered. Mr. Brooks, I need to make a ruling right now. Please stop. He's not answered my repeated question as to whether he has any additional questions for the jail administrator. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm going to have her step down.
I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhaupt is on the stand. I just have a few questions related to that, Your Honor.
I object to that. What does it have to do with she's testifying to right now today.
Bitch, you sent an ICF, and the person who can testify to the ICF that you sent, she can respond to that. That's why. And you haven't asked any questions, not one that's relevant to this COVID protocol. That was the point of this, was COVID, 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 not showering and pooping and shaving.
They're two separate issues.
I'm sorry, I don't know the document. Oh, I do have the document number, 258.
Objection for relevancy.
Hold on, Mr. Brooks. I need to find the document in my record. 258, you said?
Yes.
Objection. You got my sign, objection. Hell.
I'm just going to print that off for ease of my reference. I am going to allow the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom so that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today. How do these are two separate issues?
The court recognizes that they're two separate issues, but I also have the authority when considering judicial administration and economies of scale, shall we say. We have the jail administrator here. It's an important housekeeping issue as we go forward. And so I'm going to address it after I address the motion to adjourn that you filed. But since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Who cares?
Your statements noted of record. All right, go ahead, Attorney Opper.
All right, Ms. Wollenhop, I don't believe you have the document in front of you, but thank you,
The
Judge.
record to reflect, I'm handing her a copy of what is in the record as document 258.
Thank you, Judge. I'm sorry.
That's okay, I'll print off another copy for myself.
Okay.
Can someone confirm whether that document was given to Mr. Brooks as well? I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect, he has also been provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor. I'm not acknowledging that. I don't consent to.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed. So, and it's a document that was filed through the inmate communication form process. It was scanned in on October 3rd, but it's dated 9/29, and it's directed to either clerk of court / Judge Darrell. So go ahead.
Thank you. Ms. Wollenhop, you've seen a copy of this document previous to today, correct?
Yes, ma'am.
And you're aware that it's dated September 28, 2022, correct?
Correct.
And purports to have been written by Mr. Brooks himself, correct?
Correct.
And in this communication to the court, Mr. Brooks indicates that he is on a, quote, keep separate, end quote, in the jail.
Uh-oh.
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Lies.
Correct. That's what he states.
Okay. Is that a truthful statement?
Nope.
Well,
It
let me
isn't.
ask a different, that's a bad question. I strike that question. Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes,
He
ma'am.
was. Mhm.
Again, that would be the banker boxes of written discovery in his own jail cell.
Correct. Anything that was in his jail cell, he would have access to.
Okay.
And he would also have access to the conference room and a tablet.
And the
in
All
his
tablet.
cell.
exhibits.
Okay.
Mhm.
And that's the legal materials that are provided to him are on that tablet and on the computer in the conference room.
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do.
Oh.
You just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to. So yes,
No, I
what was
said,
in your
did
cell.
you just say in open court on the record that I in fact had access at the time of this keep separate?
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face, is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
And she knew he was going to keep
I
separate.
specifically told you that I was on the keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I
Yeah.
informed you at that time I was delivering the banker's boxes.
Listen, I forget half the stuff that's going on. Yes, I remember that I spoke to you. No, I have no earthly idea what you and I talked about unless it was something profound. So yeah, she knew that she spoke to your dumb ass and she didn't remember what you were saying. And let's just say that it wasn't worth listening to and remembering anyway. It was a bunch of bull as per usual. Munchkin, what are you doing?
And I took the liberty to explain to you that I was on the keep separate and that was going to hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
That means the same thing,
I
idiot.
do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So is there a way to verify when the keep separate went into effect?
Objection relevance.
Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it, did you have access to the banker's box of materials yet?
No,
Yeah.
I did not.
Whatever.
Ms. Wallenhoff just testified the last time that she gave testimony that she brought the discovery materials over on Thursday the 29th. She did say that in open court on
I
the
agree.
record.
Yeah, she said that previously.
This
So-
inmate request was written on September the 28th. At that time, I was already on the keep separate protocol, which does not allow me to come out of my cell.
But is the issue the keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
Because, bitch, you had counsel at that time. And then you just did your Hail Mary to fire your counsel and represent yourself. So you wouldn't have access to the banker's boxes because you had counsel. And when you had that hearing, the attorneys turned over all of their stuff to you. Freaking idiots.
the keep separate protocol in itself, Your Honor, restricts the two people that have to keep separate from being able to come out of their cell until one of them is moved. Whether that be to another unit in the pod or a different pod, that part I can't speak to, but neither of the parties are able to come out of their cell until someone is moved. And the reason why I wrote initially why I wrote it was because that stops me from being able to shower in the unit, because officers will have to then take me to another part of the jail, sometimes in the pod, in a secure shower is what they call it, which is downstairs.
Sir, I'm just gonna stop.
What the hell does this have to do with anything? What does got to do with the price of tea in China? What's the point of this? Except to waste time.
Because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare for your case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure, at the time you wrote this inmate communication form, the materials had not yet been delivered to you. Is that your testimony?
The boxes that were brought over had not yet been delivered. I had already had maybe 10% of the discovery materials that was provided to me by my former attorneys on this matter.
Right.
That in itself was very, very voluminous in itself.
Sir, we had a prior.
Yeah, it's very voluminous because you did a lot of stupid shit. And yeah, it's very voluminous. You injured a whole lot of people. You had a raggedy car. They had to do background on you, and you beating bitches and trapping hoes. They had to do all of that for you. So yeah, it was very voluminous. And then plus you have a criminal history that goes back, to the cradle. So,
prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by your defense attorneys following their discharge on your case were received by you on September 29th of 2022. That has been established. No one is disputing that. So that's the record that I have before me. I understand what you're saying about the keep separate, but also at that hearing, it was made very clear to everyone that the jail administrator gave some specific directives as it relates to you and access to certain things.
I do recall that, Your Honor.
great.
And one of the questions, if you recall, one of the questions I had about what you just said was, did all the officers know about that specific order? I guess it would be called. I don't know what it was exactly, but the information that was to be passed down from this White House to the officers.
Right. And I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear record from that is that the information was put into the jail management system. It was documented, and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So
I would like to say something for the record, Your Honor, on that.
go ahead.
to speak to what you just said on that, it's possible that all officers were not aware of that. I even talked about this with an officer who worked just last night that wasn't even aware. And his answer was that he had been off for a few days. So to his knowledge, he wasn't aware of that. And that issue came up because I specifically asked to utilize a tablet. So in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod is aware of that.
How would she know?
All right, thank you. Any questions at this point for the jail administrator?
My goodness.
Again, not related to the shower, but related to access to materials.
Does a keep separate protocol, Ms.
Oh,
Wall,
Lord.
keep separate protocol restrict inmate movement in any way?
Objection,
Yes.
relevance.
Sustained, overly broad.
And stupid.
Next question, or rephrase.
Does being on a keep separate protocol, or rather, should I refer to myself? If I am on a keep separate protocol, with that in effect,
Did y'all notice?
limit me
Dang it.
to only being in my cell and being able to only utilize
Who gives a crap?
off for a few days. So to his knowledge, he wasn't aware of that. And that issue came up because I specifically asked to utilize a tablet. So in
I want to show you the tattoo on his arm. It says Dawn.
in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod is aware of that.
Whatever.
All right, thank you. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Does a keep separate protocol, Ms. Waterhall, does a keep separate protocol restrict inmate movement in any way?
Objection, relevance.
Sustained, overly broad.
And stupid. I said that before.
Next question, or rephrase.
Does being on a keep separate protocol, or rather, should I refer to myself?
There you go. Dawn. Yeah, Dawn. If I had a child and they had my name with this busted dumbass tattoo, I would probably crack him upside the head.
If I am on a keep separate protocol, with that in effect, limit me to only being in my cell and being able to only utilize what I would essentially have in my cell.
That's a compound question, so you have to break it down one at a time. So rephrase.
Would
A
keep
drunk
separate
child did it.
protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each individual in each situation. I think it's overly broad.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial. Not generally whether you're on any kind of restriction, whether, but the focus is how this impacts your ability, if at all, to access materials needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the 28th. That was a Wednesday. And then the materials, even though they were turned over to the jail, it sounded like in the evening on the 28th, there was protocols in place to go through that. And then those were provided to you on the 29th. That is well established on the record. So I understand that.
So let it
We've
go.
addressed that in part previously. So I know the state
Let it
wants me to address
go.
this, and
Let
I
it
think I know the
go.
reason why. But if there's any question you want to ask the jail administrator about what was going on the 28th or 29th, or even going forward, that would impact your ability to have access to these materials, that's the type of questions you need to ask, okay?
Well,
Judge, I'm gonna tell you what impacted his ability to prepare for a trial. Him and this empty, I don't even know what to call it. This empty nugget right here. That's what impacted his ability and his work ethic. He's lazy. He's lazy. He's stupid. He is aesthetically challenged, and he's got that mucinex snot ball face ass nose.
I asked the question and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was going to keep separate protocol at that time?
Asked and answered.
Sustained.
More than one time.
The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next question,
I don't
please.
recall her answering that specific question.
See, this is why you write your questions down. You write them shits down. You don't go. When you have 6 life sentences and a buttload of recklessly endangering safety charges, you don't ask questions on the fly. You should have. I still just cannot get past that he was asking questions on the fly. It's crazy to me. Crazy.
Next question, please.
Mm-hmm.
Can you provide for me where she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be honored?
The record speaks for itself, sir.
And what's the record say?
Well, if the record speaks for itself, then that question should be able to be answered. Were you aware, Ms. Wallahoff, that at that time I was on a keep separate protocol, that it was already in the system that I was on that protocol?
What does this have to do with COVID? Oh, we're on something else. I forgot.
What date are you referring to, sir?
The date that you brought over the discovery materials, were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is the day that you brought over the discovery material, were you aware at that time that I was on a keep separate protocol?
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what date that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
Uh-oh.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he
Yeah,
has
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand. So I'm going to ask you one last time. Do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on the keep separate protocol?
Objection, relevance.
Sustained. All right, then I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks.
You're done.
I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already discussed.
That was in the bounds. I just asked this.
The issue is limited to the impact of the keep separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks.
So
Mr. Brooks, you indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another question?
Get on with it.
Would I be allowed out of my cell on a keep separate protocol?
It's vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the question you asked, the objection is sustained. If you'd like to ask the question suggested by Attorney Opera, that would be permissible by the court.
You know he didn't listen to it.
I ask my own question. Thank you. And was I able to come out of my cell on the keep separate protocol?
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
Can you give me the basis why, Your Honor?
It's beyond the scope.
She told you.
What does that mean? I do not understand.
Oh, for the love of God.
Mr. Brooks, do you have any other questions?
I do not understand what beyond the scope means. That was a direct
One last time,
question.
sir. Do you have any other questions?
That was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator within the scope that I've previously?
So here's my question. If Darrell has hearing issues, hold on.
Thank you.
Okay. If Darrell has hearing issues, why is he slumped over the computer? I mean, slumped over like this. He has hearing issues. That would indicate he can't see.
All right, does the state have any other witness or evidence you want me to consider related to either of these issues, the motion to adjourn or the inmate communication form dated September 28 of 2022?
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since we obviously included that after we took up the other issue.
I'm still, I don't understand how any questions that I was asking
Oh, okay.
are not.
But it's
allowed
his
to
eyes,
be
too.
answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
Yeah, I would like to, is it a way that we can verify the standards of the keep separate protocol?
Mr. Brooks?
To be able to show the
Mr.
court.
Brooks, please listen very carefully.
She tired of
There's a
you.
question I'm asking you is, do you have any other evidence?
I don't consent to being asked a question.
document? All right, then
You
I'll,
can't even answer the
all right,
question
I'm going
that
to
I'm
mute
asking
him
you.
once again. He is not answering very clear questions. All I asked him if he had any information, evidence, testimony, documents he wanted to present. Instead, he asked me if I could verify, and that is not within my role. This is an adversarial system of justice here in the United States and in Wisconsin. I preside
Come
over
on,
that,
bitch.
but it's up to the parties to present information.
You see him talking. Come on, ho. Come on, bitch. Y'all messing me up. This is y'all ganging up on me.
And make decisions. I would refer Mr. Brooks back to
He not going.
the waiver of attorney form that was discussed last week.
Uh-oh. Objection. Hey, bitch. Look, bitch.
It
You
is
see this blue sign?
document number 244, scanned on the 28th day of September 2022, wherein Mr. Brooks was advised that the judge cannot be his attorney, cannot give him any legal advice. The district attorney cannot be his attorney, cannot give legal advice. The judge, district attorney, and court personnel are not required to explain court procedures or the law, among other things, and that he is required to follow all legal rules and procedures that an attorney would have to follow in court. He was also advised, and this is just one part of that form, that it may be difficult for him to present evidence, may be difficult for him to do a good job as his own attorney. We discussed at length the advantages to having an attorney, the disadvantages to representing oneself. And what he is asking this court to do is to explain the law, and could also be described as a request for legal advice. All right, with that then, I'll certainly take up any arguments from the parties as it relates to both of these issues. I'll start first, though, with the motion to adjourn. Mr. Brooks is holding up the objection. That we're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further, other than to say the fact that he's objecting is noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings, and as such, I will give you the first opportunity to talk about the evidence that I've heard here today by way of testimony, and to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing.
Idiot.
I stated pretty clear why it should be an adjournment. I don't think I need to argue anything. I don't think I need to provide anything more. If it's clear to me that the wrong person was testifying. She said that she was not present for.
It's clear to you, stupid bitch. It's clear to you. It's not clear to nobody else because we don't speak stupid.
The said COVID test.
So we're back to COVID.
To her knowledge, no way to say for sure why I wasn't provided with the test that I should have been provided with if that becomes an issue. Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you.
Oh.
I don't feel good at all.
Oh.
My reason for raising this issue, like I said, was strictly a health and safety thing.
It didn't have anything to do with trial prep. It didn't have anything to do with access to anything.
You brought
It was strictly because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly, I'm terrified because I have yet to even get the results back to say whether I'm positive or negative. I am fully vaccinated.
Okay.
I've never tested positive for COVID. And frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid.
Okay.
Which is one of the reasons why I was so concerned about the actual protocol, because once they informed me that I would have to be essentially quarantined and isolated, the first thing I was thinking about was how would I be able to use the phone that day, be able to tell my family what's going on? How would I be able to reach out to my kids and things like that to let them know, hey, I got a health issue going on in here that I'm worried about? That was my concern. And my intention was to at least be able to get the results back so that I know, okay, I'm good to go. Let's keep the ball rolling. That was my intention.
You don't want to keep the ball rolling.
Like I said, I just came to the knowledge this morning when they called me over to do the test. I had no idea that was what they were going to do. Like I said, I didn't understand the protocol until it was explained to me. So I'm just coming into this knowledge as well.
Oh my gosh.
I'm still trying to wrap my head around it.
It's a big head.
With that, Your Honor, that's pretty much all I have to say. Is the intent of it was strictly that. And, not one to, if I am positive, not wanting to infect anyone else or put anyone else in jeopardy.
Oh.
And also doing the things that I may need to do if I'm found to be positive, doing the things that I need to do to be healthy. That was my concern, and that's why I raised the issue, Your Honor.
Y'all, he concerned about the health and welfare of the people in the courtroom. He's concerned about the health and welfare of the people in the courtroom. How wonderful that he cares so much. Darrell cares. Darrell is for the kids, except for the ones that you killed and ran over.
Thank you, Mr. Brooks. I'm going to turn to the state then next. As a reminder, don't interrupt them. Thank you.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. I also would like the court just to acknowledge that document 258, and perhaps that's a moot issue at this point, but I still think a record should be made that no matter what circumstances have arisen with Mr. Brooks specifically in the confines of the Waukesha County Jail. He has always had access to his legal materials, the discovery in his cell, and the necessary tablet and computer so that he can prepare for his case. So I would ask you to deny the motion to adjourn because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
Thank you. I'm just pulling up a couple of documents so that I can review them electronically as I make a decision here today.
What you objecting to, Ho?
Your Honor, may I state something for the record?
You may briefly respond. Go ahead.
If all parties will recall, one of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey.
Wait a minute.
Similar with
So you knew who he was? Oh no, you didn't know who Jason Statham was. You knew Detective Casey. My bad. I'm sorry.
COVID and was not present for a couple of hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk. I don't see where there's any difference in my situation. Also, very briefly, for the record, I was able to make a phone call. Phone call attempts, because they were attempts, this morning after I came from getting the test because I raised the issue. I said,
So let me guess. The 17 attempts was for Erica. I bet you any type of money he was trying to call Erica. Maybe his mom was in there too, but I bet it was Erica.
since I know that I'm going on this protocol and I'm already out of my cell, can I take this opportunity to try to notify my family of what's going on? That's why there were so many attempts, because I wasn't able to reach my mother.
Oh, he called his mama.
Who pretty much has access to my kids if I need to get some information to my children.
You are such a liar. You are such a liar. Your kids are on all over the United States. What are you talking about? Oh, I'm worried about my kids. When? Bitch, when? When? You haven't been worried about your kids, period. You have not been in none of your kids' life. Not one of them. Not even Missy, your light, your daddy's girl. You hadn't been around her. She in another state. Xavier in another state. Away in another state. Come on, man. Quit lying.
She's the one that is in charge of all that.
Right.
I just wanted to state that for the record.
Thank you, Mr. Brooks.
My God.
Court has heard from Mr. Brooks. The court has heard from the jail administrator. The DA has provided some additional information as officer of the court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive. He provided information today that he is fully vaccinated, that he'd been telling officers for days that he had not been feeling well. We do not have the test results today. He was offered a rapid test and refused. He reports symptoms of fatigue and that he can't taste. He also indicated it was a few days ago over the weekend that he started.
That's right, California Dreamer.
These symptoms.
Back half of the week.
Now, during his time here today, Mr. Brooks, despite the disruptions, has been very clear, coherent. He has asked questions. He's made objections. I know he might not like the word argument, but that's a word that we use in the adversarial system.
Quit blowing smoke up his ass. Okay? Quit playing kissy face with him. He didn't ask any questions that were relevant. They weren't cogent. They weren't succinct. They didn't make any sense. He objected improperly. He didn't know anything at all. Quit lying. See, you lying, Darrell. See, you lying. And you ought to be ashamed of yourself for lying.
When the court asks the parties for their positions on certain issues, we call it legal arguments or arguments for short. Doesn't mean or have any connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to articulate his positions to the court. He at times appeared animated. He appeared, again, to understand what the court's either questions that the court was posing to him or information the court was providing to him. He clearly was able to Mr. Brooks, please don't interrupt me or I will mute you. He was able to follow the questioning and answering process with the one witness who is here today. I appreciate that he clarified that he was not making this request due to trial prep or access to material issues, but it was really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And given my observations here in court today, he is very able to assist in his own defense. He's able to present arguments, etc. As I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom, there is no one around him who would be within 6 feet. That is an important consideration that has been one of the topics of guidance from the CDC, certainly one of the, or part of the guidance we have received from the county. The most recent county protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing. The court will find that there are no present health and safety concerns other than what I've noted with the 6 feet and social distancing. I'm not going to adjourn this trial. I'd also put on the record that he has not been denied access to materials. He has full access, even with this protocol. He has had access even to the phone. There's been what's been referenced by both the state and Mr. Brooks about attempted phone calls. I'm not so concerned about whether phone calls go through. It's the fact that he's been given access. Whether he connects with someone is not the issue. I'm also concerned about the fact that he would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately. And he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19, and that any health and safety
It wasn't COVID-19. Oh, I was
concerns.
It wasn't COVID-19. It wasn't COVID-20. It wasn't COVID-30. You didn't have nothing but lies.
We can keep him 6 feet away from any other person. Obviously, if he's removed to the other courtroom, that provides a greater buffer as well.
He'll be there plenty of
and
time.
For all of those reasons, I'll deny the request to adjourn. As to the issue that was raised in the inmate communication, obviously this was a form that was sent by Mr. Brooks on Wednesday, September 28th of 2022. That was the day on which this court granted his request to represent himself. We know from the record, not only from today, but previously, that on September 28th of 2022, what he would have had in his cell would have been materials previously provided to him by his attorneys. His attorneys, through Attorney Perry, dropped off 3 bankers' boxes worth of materials and a flash drive to the jail later that date. And the jail followed whatever protocols they have with
Come on, hurry up, I'm
those
sleeping.
materials and reviewing them, and that those materials were provided to Mr. Brooks on September 29 of 2022. He's confirmed through the most recent request to adjourn that he wasn't even making that request based on any type of access limitation to materials or things of that nature. Although not a specific statement by him, this court would take that to mean he has been able to continue with his preparations. I'd also put on the record that there's no doubt that being in trial can be exhausting. We, of course, had 2 afternoons of hearings last week. Of course, he was provided with a lot of material. From my perspective, he clearly understood the perils of self-representation and the volumes of material that he would need to review perhaps a second time because he had some of them, or for the first time. Those were things that were clearly, he was clearly advised of before.
Oh, Lord Jesus, come on. Help a cat.
Locate that. I am putting that on loan to Mr. Brooks. What he also needs to understand, though, that at this point it is for use in the courtroom. I would entertain a request that it go back with him to his room on a couple of conditions. One, it would be that he agrees to bring it to court each day. 2, that it be maintained in its current condition. And then 3, that it's returned at the conclusion of the trial. So that will be for him to decide how he wants to do that. He has been raising the sign objection at all times during my oral decision. I would note the use of an objection is when the trial is in an evidentiary phase or a motion where we're talking and addressing the receipt of testimony and then the parties sign. I'll tell the parties what's on my list and then consideration of 11:18 this morning. He was on the book, so I can cross that off to make, or it's really just time, but I'll get.
Yes, Sharon, I just wanted to understand some of the logistics as far as objections and cross.
Let me find it because I'm sleepy as hell. Let me see when they did the. Oh, it's not on this stream. Oh, what is this? Here in part 2. I'm gonna have to do that when we'll pick that up the next time. I'm about to pass out. I'm sleepy. It's all get out. So I'll make sure that I come back and play the COVID results because I think that might be on on trial day 1, but I'm not sure. But I'm fighting to stay awake. So, I'm about to be 29, for the 1,000th time. I'm gonna be 29 on Saturday. Sunday's my birthday. Yes. So I'm gonna be 29 again and again. Yeah, I think it's the next day too. Hold on. Let me see. And we're looking for Darrell Brooks day 1. And then let me see if I can find the COVID protocol. Okay. That's her reading to the jury. Y'all remember what part of day 1 this was on? Was it? I think it was toward the end of the day. Let me see. Hold on.
Rules of procedure, the rules of evidence.
Your Honor, I did
That's
not,
the playing field that you willingly entered into and made a deliberate
did not.
decision to waive your right to an attorney
I
and
can,
to appear
I
in this
consented-
case
I
as your own
consented
attorney.
to represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand that despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to read.
Okay, I have to find it because I don't know where it is. And like I said, I'm about to go to sleep. Anyway, guys, thank you so much for stopping by so we can make fun of this idiot yet again. We just gonna start this trial over again. And like I said, I am gonna do some YSL. More than likely, I'm just gonna hit Little Woody's testimony. And I know that some of the other YSL members, like the one that said he was so high he was about to fall asleep. I got to get him and some more stuff. I am going to do the Tiffany Henry thing. So don't worry, that's coming. You said after lunch on Friday. Let me see. And the trial started on Friday and it was after lunch. See, it's not like Glanville, his after lunch is, who knows? I don't know where it is. I think that's probably the lunch hour there. That's him in the courtroom, running his dick suckers. Let me see if
relitigate
You
that
also,
here right
you also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Okay, I have to look for it. I'm sorry, y'all. Like I said, I'm gonna do that. And I got some more stuff with the Dakota Collins case that I found. And I just will tell you that it's even worse than the things that we already know. So I'm just giving you an early trigger warning, but I do hope that you come and check out some of my streams with the additional content. I know that y'all like Darrell Brooks, but I try to pull very interesting cases. So please, at your leisure, check out my other content. It would be greatly, greatly, greatly appreciated. Well, everyone, please enjoy the rest of your night. Get you some rest. Enjoy your weekend. And I may come back maybe tomorrow. We'll see how I feel. But anyway, I want to thank everybody. I appreciate everyone who donated. And those who had the heart to donate but just didn't do it. And thank you for all the birthday wishes. I really appreciate it. And the last thing I'm going to say to you guys is drums, please.
Drums, please.
Ladies and gentlemen, we have had a great time tonight. We have truly enjoyed ourselves, and we would like to thank you for being a part of the show and coming to visit this platform. Live on YouTube.